deeper. So we still have to dig a little deeper in the success stories also. So that also has to happen. But Darren, thank you very much for being part of this symposium, earlier ones, and it's been a pleasure speaking to you and looking forward to this one. Now, the only thing is, Darren, I want you to tell us about yourself, or at the same time, what I'll do is let me put up what we are doing. What do you think?
Great.
That's good. Yeah.
Okay, well, look, thanks for having me again. It's always lovely to talk to you, and thank you for all your work that you do in this space. And I've watched a few of the sessions so far, all very interesting in their own particular way. So a big thank you to you and all the work you do for the Mediator community around the world. A quick bit about me. My name's Darren. I was a practicing litigator in London for many years. I moved to Auckland in New Zealand about six and a half years ago, I think, and have been a practicing mediator for nearly all of that time. I was in a lot of mediations as a lawyer, and sort of felt this was my calling. It appears to be so. I'm married with two kids. My children are 8 and 6, and they've just got back today from a bit of a holiday with their grandparents, and they've had much fun. So been getting filled in with stories from them this afternoon. And apologies for anyone who was waiting for the live channel. That was me on the motorway trying to get back home from delivering a mobile phone that my father-in-law left behind this afternoon. So an act of kindness, but so I hope you can all forgive me for Vikram's channel running a few minutes late this afternoon.
No issue at all. These are part of things happen. Now, look, normally, of course, the idea is always to go on time, but the sessions otherwise were 30 minutes, so back to back. So getting late on one would mean that the other, either this person won't get time or the other person won't get time. So I said, let's do it on time. So this is what we're doing. Mediation legislation, the how, what, when, where, which, who, why of it. And of course, you've seen some, there's been, of course, certain direction that I feel that we've got, but let's take it. We have a workshop. We'll discuss it at the workshop and try and put all of that together. Although I'm the only one maybe who's watched all the sessions and been part of it. So
of course.
everyone doesn't have that benefit, but taking from there. So Darren, please, mediation legislation, all yours. But
yeah, great, thank you.
Okay. Oh no, what I didn't do, which I should do actually, but doesn't matter. I always do try and put up my website only because
you do put up your website. Show your website. Don't be shy.
It's the idea of putting it up there is that at least I basically want one space. It's like a notice board. I call it a notice board, just to go there and make life easier for me. That don't ask me to keep posting things because they're not going to be seen by everyone. And it takes time to put these posts out. So why don't I go here? I'll just update this. And of course, Magic in Mediation is the new series based on Ken Cloke's coming out with a book, Magic in Mediation, end of the year.
That's right.
So his session is already on the channel. And then there's another one from Mr. Panchu in India. Tomorrow we have one with Michael Lang. Day after with Andrea from Ireland. So this will keep happening. And of course, the World Mediation Circle with Darren is I think he's kind of on it now. He thinks now the philosophy behind it seems to be all right, because like you put that post up about these children and about how they have that mindset and all that. So I'm happy that Darren is going to be on that. We'll do some interesting things together. So this is what it is. Of course, last to last year, Ken Cloke and all that. So I think that's about it. Let's not go any further. We have taken, all the 45 minutes, I think, is also a better session than the 30 minutes that people have had. So please, Darren, now it's all yours. I'm out.
Okay. So I wanted to talk about mediation legislation from a New Zealand perspective. There is no Mediation Act legislation as there is in, say, India or Singapore, which have got some great acts specifically for mediation. And in New Zealand, there are over 60 acts of parliament which formalises ADR, which reflects, I suppose, a direct towards ADR in the country as a really good option for resolving disputes. mediation here takes place in a wide scope of areas of disputes, and some of those areas that I've just touched on are formalised in Acts of Parliament. There are things such as the Farm Debt Act, health and disability, family, employment, landlord-tenant, weather-type homes, resource management, personal injury claims, and natural disasters. So there's a widespread dispute resolution processes, mediation and arbitration, but we're talking about mediations today. It has been said by a few people that I've spoken to that there is a wide divergence among the mediation models in the different areas of dispute, particularly in the terminology. So, for example, we have things like mediation, conciliation, facilitation. Some of the acts talk about pre-hearing meetings, settlement conferences. And the discussions I've had with people is that this can be a little bit problematic for people because you have different models. Some of them contain specific features, procedures, which it can be argued affect in people's minds the fairness and the effectiveness of mediation, because it doesn't have a mediation act. And a good example of the divergence that I can give to you is in the family space, which is known here as family dispute resolution. And there are 3 providers who have got contracts with the Ministry of Justice. And the process in all 3 of those companies that have got a contract with the Ministry of Justice, they all have a completely different designed process from the providers. So, if you're a person who applies to one of these providers or applies to another, you can have a completely different journey. I appreciate that mediation as a process is slightly tailored in every matter. I appreciate that, but this is the divergence that we see across the board. Access to state-managed mediation services is simple, and until quite recently was inexpensive due to the cost of living, less so inexpensive, I suppose. And some acts require the parties or participants, as you like to say, Vikram, to take part in mandatory settlement procedures before they're permitted to commence adversarial court proceedings, which in my mind is a good thing, but there's another discussion around a voluntary process, which I suspect we'll touch on a bit later. I was at a conference a couple of years ago, and we were talking about FDR mediation, which I think it came in about October 2014 in New Zealand. And there was this part of the act allows the family court judges to refer parents to mediation, but there was just nothing was sort of coming through the court system into that space. And a retired family court judge who was sitting in the room full of mediators, he explained to us all that the courts weren't referring stuff to mediation because the judiciary was not consulted by the ministry when it brought in this act. So I think they got their backs up a little bit. They kind of thought, well, are we going to be losing our work here? But there was a real slow take up of mediation by the judiciary. We started to see a bit of a trickle come through now, and judges can see the benefit of their time being used on extreme cases that really do need judicial support. An interesting, just picking on the Family Dispute Resolution Act, in order to sidestep the requirement for mediation, the only way that you could do that was if someone applied ex parte or without notice to the other person. And I think the intention is that a lot of the cases would come to mediation rather than to the courts. But in fact, what happened was a complete 180 degrees on that. So the ex parte or without notice applications increased heavily after the act came into force. And a few statistics here. So in 2013, when the act wasn't in force, the year after, there was a 14% increase in ex parte applications, an increase by 22% in 2015. And that number has increased each year from 2013 to a whopping 43% in 2020. There's been a slight decrease in ex parte applications since 2020, but just by a few hundred nationwide. And in thinking about what to talk about today, I came across an article by James South from the Civil Mediation Council in the UK. And he wrote in 2020 that there were almost 247,000 cases issued in the courts in the UK. And he estimated there were 16,500 commercial mediations in the same period. So a huge disparity, and a trend that I've just mentioned there from the family dispute resolution, mediation, stroke court proceedings. And we do know that there's a disparity of disputes which people find themselves in a mediation space against those who find themselves in the court system. I just wanted to talk a little bit about the Residential Tenancies Act here, and that has established a model of mediation, which is slightly different to any other mediation that I can think of here in New Zealand. So part of the Act says that mediators may make such suggestions and recommendations and do all such things they think right and proper to induce the parties to come to a fair and equitable settlement. So this wording is actually a separate function, as I see it, to mediation, which is usually assisting the parties or participants to bring around a settlement. And it makes it highly probable that the provision actually gives the mediators power to give substantive advice, which was a bit of a concern for me when I read that act. I don't do any work in that space, but just for today, I could see how the act really sort of shifted a mediator's role in those types of disputes. Now, I've touched on this before, that the Act here differ greatly in defining what the mediation process is. Some are rudimentary, and some are really detailed frameworks which we have to work in. And I sort of was thinking about whether any Act of Parliament should prescribe the mediation process. As we know, as a mediator's processes are flexible. They fit the purpose for the dispute and the people who are involved in the dispute. During COVID-19, the government here announced funding for landlords and tenants to participate in mediation or arbitration. There wasn't an act, but it was a scheme that they'd put up, and this was around people who couldn't get into their commercial premises during lockdown to try to reach an agreement with their landlords for rent. And unfortunately, and as a result, not many people applied for the service. And I've spoken to a number of landlords and tenants post-COVID who all described, thankfully, able to reach agreements themselves for that period. And I think I was one of the few mediators in the country that mediated a funded landlord and tenant dispute because of COVID-19. And I just wanted to give you, everyone listening, a little bit of an idea of why I was talking about wide divergence. I've got a few examples of so you can understand how the Act applies, where the Act is silent or where it gives a detailed framework to work in. So here, there's in New Zealand, there's an act called the Property Relationships Act. So that it applies to all married civil union couples who've been living together for a minimum of 3 years, and whether they're the same or opposite sex. Now, there's nothing in that act about mediation at all. However, I frequently mediate in that space, and I know lots of my colleagues who do as well. That's where there's nothing in the act at all, and yet there's a frequent flow of mediation processes happening every day in that type of dispute. Family dispute resolution, which I've touched on earlier. This is for parents that have separated and how they're going to co-parent and care for their children. And I'm going to read out a couple of parts of the Act just to give you a bit of a feel. So an FDR provider, that's the mediator, must determine whether it's appropriate to start a family dispute resolution process and types of cases that might not, as if there was a safety issue, if a parent or child safety was at risk. And once the mediator has determined that it is appropriate, they must then use their every endeavour to, one, identify the matters in issue between the parents, to facilitate discussions between them. 3, assist them to reach an agreement in a matter that best serves the welfare and the best interest of the children. There's a bit of a pet hate coming to you now, Vikram, I'm afraid. Section 9 of the Act says that the Secretary or an approved dispute resolution organisation, they can appoint a person as a mediator, as long as that person is qualified and competent to provide the services intended. And in deciding whether a person meets that criteria, the Secretary or a dispute resolution organisation who has a contract with the Ministry of Justice, they must apply qualification and competency requirements prescribed by the regulations. And they are, you're going to hate this as well, whether you're a member of a specified body, you must have relevant experience, and lastly, you can't be disqualified for example, you've got a criminal conviction. And interestingly, the Act says that an appointment, so when a provider provides a mediator with a case to work with some parents, that the provider can appoint them on any terms and conditions that they deem fit. So the mediators are appointed on terms in those types of cases on conditions that they have no say in. So this is quite different from the relationship property matters where there's nothing in the Act and people come to mediators, whereas in the state family funded space, mediators are just told that this is how it works and this is your contract to work within. And there is a mandatory requirement to undertake family dispute resolution mediation before you can go to the family court. In New Zealand, there is no personal injury claims at all. There's a corporation called the Accident Compensation Corporation, and everybody pays a little bit into the pot. And the purpose of the Act is to enhance public good and to reinforce a social contract represented by the Accident Compensation Scheme, provides a sustainable scheme for managing personal injury, and it gives people things. It's a no-fault system. And if an injury is caused by accident, you are entitled to cover for the injury that you suffered as a result of the accident. You get treatment for that injury. If you can't work, you get 80% of your income, and other entitlements such as surgery and rehabilitation if needed. Now, I regularly mediate in the ACC space, and the Act is a very long, detailed and complex. I think it's got over 400 sections in it and about 15 to 20 schedules, perhaps maybe more. I haven't looked at it recently, but there's no right for mediation within the Act at all, except for between the insurance company and the corporation. That's the only mention of mediation, and yet there are mediations happening daily in this. So again, just nothing in the Act, and yet it's happening day in, day out. Recently, in New Zealand, there were some changes to the Trust Act here. And that I suspect going to in the next year or so, we're going to see a lot of work trickle through into ADR. And interestingly, there's Section 145 of the Trust Act 2019 gives the court the power to refer a trustee or a beneficiary of its own motion to mediation or arbitration, which is a really interesting new thing that's happened in New Zealand. So here, where the court can refer them, whether they want to mediate or not. And again, I think this brings up a whole different discussion around mediating with people that perhaps don't want to mediate, with it being a voluntary process. But quite interesting that the court can refer people to mediation or to arbitration if it sees fit to. And I can see some real benefit with that on a small scale, not perhaps for the whole dispute, but particularly you can see a value for mediation or arbitration where, let's say, a deceased has got some shares and there's a dispute over the value. That could be a satellite issue that could be dealt with pretty quickly and speedily and cost effectively by mediation. I'd hope arbitration as well, but maybe not. Then there's I wanted to talk briefly about the Farm Debt Mediation Act. This is quite a new act in New Zealand, and the purpose of this act is to provide people with farm debt, so whether that's farmers or banks, with the opportunity to use mediation to reach an agreement and to present arrangements and future conduct of financial relations between them before any enforcement action is taken in relation to farm property. So a farmer or a creditor may request mediation, and if the other person agrees, mediation has to be completed within 60 days. So it's a really good use of mediation where historically banks were taking possession of farms. So this allows long future relations to remain, farmers to remain on their land, excuse me, and to keep their business running. And last act here that I wanted to briefly touch on, we spoke about this last year in the colonisation decolonisation symposium when I discussed with you the Waitangi Tribunal here. So the tribunal came about from an act, the Treaty of Waitangi Act 1975, and the tribunal has a role into making inquiries and recommendations on land claims. It has to examine and report on proposed legislation, and if so, refer those back to the House of Representatives or to a Minister of the Crown. And it also makes recommendations or determinations about Crown forest land, railways, excuse me, state-owned enterprise and land transferred to educational institutions. After a complete hearing, the tribunal panel writes a report that has detailed findings, and it can take time for reports to come out depending on the size and the complexity of the inquiry. Some reports that come out within weeks or days, and some take up to several years for those large and complex inquiries. And then those reports are interestingly used to assist the participants to a dispute. And the Office for the Crown, the ministers for Maori Crown relations, who then sit as facilitators to settle negotiations. So mediation comes as a second part after the dispute. So you have a determination by way of a report, and then we come to a mediation, which is a really interesting way to do it. I suppose your question on the why here is, I suppose, a bit relevant to what I've just been talking about, Vikram, because I've given you a number of examples of frequent disputes that come to mediation there in New Zealand. Two of them are mandated by legislation. One of them, the court can direct the mediation. One is quite prescriptive, and the last one, mediation, comes after a determinative process is completed. And I was sort of thinking back to my earlier comment about possible confusion around the wide divergence among models, language, terminology. And you can see how this could be easily confused by people who want to mediate with all of these different ways of doing it and different models. And I was thinking about this a little bit today. Many countries have an arbitration act, although nowhere near as many have a mediation act. So like India or Singapore, that do. And I can see the real benefit here for having an Indian or Singaporean mediation act, which makes it clear for the mediators and for people who want to mediate. It gives them some clarity around the process. So I just turn my light on. I'm getting a bit, we're out of summer months here, and we're getting a bit sun going down. So make sure what you can see. I was just thinking about the Singapore Convention a little bit before today, and just tapping on my comment I've made a few times about different terminology. Interestingly, the model rules call the mediation process mediation proceedings, which feels to me more like arbitration or court. Interestingly, New Zealand hasn't signed up to the convention yet. I have no idea where the government is and its thinking around signing. With over 60 acts of parliament here supporting mediation and many more types of legal disputes regularly finding their way into mediation. New Zealand is a mediation-friendly country. A number of its key trading partners like America and China have signed the convention. And it sort of struck me that because here is such a mediation-friendly jurisdiction and its major trading partners have signed the convention, it would be really advantageous for it to sign the convention, but it's not for me to make decisions on behalf of New Zealand. I had a little look at the UN rules on conciliation back from 1980, and it struck me how far confidential settlement discussions have come in 40 years to where we are now. And Article 13.2 of the 1980 rules, where it's talking about settlement agreements, it says if the parties reach agreement on a settlement of the dispute, they draw up and sign a written settlement agreement. And if requested by the parties, the conciliator draws up and assists the parties in drawing up the settlement agreement. And there's a footnote just in that paragraph about settlement agreements, and presumably enforcement would be one of the things that they were thinking about. And the footnote says the parties may wish to consider including in the settlement agreement clause that any dispute arising out of or relating to the settlement agreement shall be submitted to arbitration. So now we have the Singapore Convention that cut out the use of arbitration. We now have sort of what's more, I suppose, likened to a summary judgment type application to enforce a mediation agreement when it's done through the Singapore Convention. One of the things that I observed about the Singapore Convention, that's Article 14, which is talking about confidentiality, where it talks about the conciliator and the parties to keep confidentiality throughout, and that also extends to the settlement agreement, except where its disclosure is necessary for the purposes of implementing enforcement. And I was thinking about, well, how this could strike me as a difficulty with enforcement, because Article 4 talks about the basic evidence, and that would be presumably the agreement. Would be an obvious example for basic evidence that you'd need to enforce it. I mean, I personally don't sign mediation agreements, and if a mediator, unable to be called to give evidence, if the mediator's signature is not on a document and there's a dispute about it, we know that the process is confidential, it's well established, and it underpins mediation. That could be one of the sort of sticking points on enforcement and not being able to breach the confidentiality. And I was looking into this a bit more, and I noticed from Article 10 of the model rules that it says that unless agreed by the parties, all information relating to the mediation shall be kept confidential, except where disclosure is required under the law for the purpose of implementation or enforcement of the settlement agreement. So heavily sort of driven towards enforcement. And section 46 of the UNCITRAL notes on mediation states the mediator is generally expected to keep the mediation, including any information related to or obtained during the mediation, confidential. The duty of confidentiality usually not only applies to the mediator, but also to all others involved in the mediation. And it's advisable that all those involved in the mediation should be covered by a confidentiality agreement. And then section 79 of the notes it's advisable that the parties state their understanding that the settlement agreement can be used as evidence that resulted from mediation, and that it can be relied on for seeking relief under the applicable legal framework. So this is something, I suppose, for all those to think about who are involved in international mediation, and the right way to deal with enforcement if enforcement is required. And I had a little look at the Singapore Mediation Act and the Indian Mediation Act, which were really interesting to read. I know of a few mediators that are practicing not only in New Zealand but Singapore. It's not that far away. It's opened doors for mediators here who are practicing in both there and here at this jurisdiction as a direct result of that Singapore Mediation Act. And I think this is really interesting for mediation. I wonder how many mediators you might find in India, Vikram, potentially, if they join up to the body, the council, and could this be a bit of a snowball effect where we have us all potentially practicing in all different jurisdictions physically as well as online potentially. So just thinking about it all in the round, really. I was thinking about here in New Zealand. I think given the disparity of the number of cases that go before the courts and those that find their way to mediation, I think I'm for a mediation legislation, specific mediation legislation here. I do note there is a tension between a truly consensual process and one that's mandated by Parliament. We have anecdotal success rates, which are frequently thrown around, that mediation sits successfully at around 80%. So, there's a great reason to mediate to start with. And hopefully I've spoken a little bit about your question: how, what, when, where, which, who, why, for your symposium.
Good. Thank you very
and
much.
how it works here. And what main threads have you come across? Sort of, you've been involved in all of the discussions, Vikram, from our colleagues across the globe. What's everybody's thoughts on domestic legislation? And has anything struck you in particular from our colleagues across the globe about having a national mediation act?
Look, the thing is that, of course, countries have put that in place. Those laws are there. The important thing is that whether those are actually being used. Is mediation being used? Because you can put legislation, we've got this since 1996, what we've got, but the usage of it, of course, I keep saying that how do we know if it's being used or not? Because only if it comes into court will you know whether there was a conciliation or not. So maybe it's being used in a very widespread way. Who knows? Although people keep saying, no, it's not being used. So that part of it, debate will happen. But the important thing is that in terms of legislation, like I said, the Ecuador example, I really like that because their focus has been on people experiencing mediation. So there is no court mandated mediation. So there is no mandatory mediation, as we call it. Why we call it that, I don't know. That oxymoron we'll discuss later. But so there is actual experience happening. They're doing a great job. You must watch that session with Gabriela and Jimena, because this is somewhere where actually things are happening. Now, only thing is that whether we have to consider population at the same time, because they are 18 million. So in 18 million, does a certain thing work which doesn't work in a 1.4 billion? So that has to be looked at, because the thing that has happened there is that they've got they've put together mediation centers, and the concept of course, the certified route they've gone. So now mediation centers have training programs, they certify mediators. So now what I was discussing with them also, that over time what will happen is, because you'll have large numbers coming in, Gabriela herself was saying that she does training and there are 50 people in that Zoom session. How do I actually have a productive kind of a session? Because at the end of the day, those guys are going to be certified. They say videos are off and I can't even see all of them on one screen. So it'll go in that direction. That for me is a bit of an issue, which might have an effect on them. But what, of course, Jimena said that there is a large number of positive things that have happened. So there are positive experiences that are happening. So maybe certain negatives will be taken care of there. In other countries, there are not enough experiences to actually counter the negatives that will happen. So the market, of course, the market will decide, market will take it wherever it has to take it. And if there are no more people coming out, the experiences are happening, word of mouth will happen. That's the way I've been always saying, that's the way it's going to go. It has to be word of mouth. And of course, the grassroots activity of people experiencing it in whatever way. It could be in the smallest kind of a dispute. Ultimately, a small dispute also takes you through a process where you do take back a lot. So I think that's now down to people experiencing it. And for me, legislation should not come in the way for that. So of course, you go through the certified route and things like that. So are we really going to be putting enough numbers out there? Or are we going to put numbers which don't make sense to the people? Because the user is who's the, I mean, we have to focus on the user. And like you were saying, in terms of legislation, there also, the user is going to get confused with so many things happening on the process and all that. I think the user has been left out on legislation, as it seems. No one is considering the user. People are getting into maybe lawyers and of course the judiciary getting involved. Like you said, the judiciary wasn't happy when they were not consulted. Now we have to look at whether judiciary should be consulted, because it is a process which they, of course, it's not their process. I mean, it's totally opposite of what they do. And for them to understand it and give their suggestions would would it be in the right direction at all? Because they have a self-interest. I don't know. Look, in terms of numbers in New Zealand, what are the court cases? How many pending? What's really happening there that you have to tell us? Because that is something which does come up, that efficiency of the judiciary or the inefficiency of the judiciary being connected to mediation. I think that's something which we have to, of course, look at, because the inefficiencies should not give the direction to mediation, which is what has really been happening. And it's, of course, going into absurd directions. But I just felt that this aspect of the Maoris and their processes, has that been considered and some kind of acceptance given to their processes or their mediation processes in some way?
Do you mean in terms of where they sit within the statistics, or their sort of their own way of
Own way,
resolving?
the own way of resolving,
Um,
is there some support for that in terms of the, of course, enforcement on one and otherwise?
I think, I mean, look, I've been here for about 6.5 years, and what I've noticed in that time is that the Maori culture has become much more interwoven with the day-to-day here in New Zealand. So their native tongue is being spoken on national radio very regularly. In schools, it's taking much more prominent. And I can't imagine it will take much time before the way that they deal with disputes will form part of it. There's I think I touched on this last time. This process called tikanga, which is a Maori way of doing things with certain protocols. I suppose so I don't think there's any direct information that I know of. There may well be some, I haven't looked at it. But I remember my wife telling me a story. So my wife's an optometrist, and she was saying to me that the healthcare system here is set up in a European way, where you get a letter through the post saying you need to come and see the doctor in 2 weeks' time at 2 o'clock. And that's not the Maori way of doing it. What you do is you call and talk, and you work out a mutually convenient date and time, a bit like mediation, I suppose, for them to come. And then they come with whānau, with family members. And when my wife asked Maori patients how's their health, they don't talk about themselves. They talk about all of the other people in the room and the other close family members who are not in the room. So it's like a collective being. And the more and more I sort of hear and learn about Maori culture, the more I think that everybody would benefit from doing things their way more and more. So I don't know. Certainly, what I can say to you is that their participation in mediation is way below the national average of a population size. I think Maori population is about 15%, I think, in New Zealand, and the statistics are way below that for their participation in mediation nationwide, which is a real shame. And I think we've got lots to learn from them.
But in terms of percentages, in terms of the number of cases where the Maoris are involved, is that higher than that 15%?
I think in the criminal justice system, you'd probably say yes. And I'm not sure about in the family courts, but there is a higher percentage of Maori Pacific who are in the criminal justice system than the general population. And this is a trend we see across the world, right?
Well, I'm just thinking that in terms of even the criminal justice system, because of course restorative justice is spoken about, but mediation in criminal matters, whether that can be accepted, because obviously on one end we have the colonial laws, when the colonial laws will definitely not want that to happen. And I don't know, are you still continuing with colonial laws, or have you updated the legislation in general?
I'd say a lot of it is based on colonial law. There is some really nice changes that have happened when we spoke about on the decolonization talk. There's a really nice act of parliament here about a river, and it's taken the old legal framework and got a Maori worldview interwoven in the act. Which is really nice. So the act was all about to bring around assessment from the government to a tribe and in order for compensation, if you like, to be paid out, the river had to be given the rights of a person. So the riverbed, the water, the air above the river was all a legal entity, and it was allowing this legal entity, and the legal entity was prescribed by Mori view. So it was all the things that they believed is the river itself. So that's why it's the soil, subsoil, water, the air above it. And that was a nice way to interweave Maori culture into a colonial style act, I suppose, if you can put it that way. And that worked. It worked really well.
But I'm just thinking that why I'm asking about legislation is because the mindset of the legislators, is it moving towards looking at, of course, bringing in the indigenous peoples and their methods is one thing, and generally, of course, there's a thought process, and in that thought process changing, because that will be something which will definitely come down to mediation. Ultimately, that is a process which goes against that whole colonial structure. It's a different mindset altogether, which, of course, I keep saying that our law breaks out of that. But the moment you don't have any involvement of the judiciary and government, that's a big step for a country to get into. So I think that is where the thought process comes in. But you should watch even the Turkish example. Turkey, in terms of success, when you look at numbers, is amazing. The only thing is that digging a little deeper as to why that is happening. Is it because in labor matters, of course, it's used majorly. So that she was saying that 3 million matters total 3 million mediations happening.
Wow,
that's huge. So now in that kind of situation, one, of course, it came out in that of course in labor matters, is there a choice that they have otherwise? Are they just doing it because they don't have a choice? And power imbalance is playing a role in that whole mediation and in the court process also. So is that the reason why that's happening? But numbers are there. So if you see statistics, amazing statistics. So I did have, of course, 2 sessions with her, because half an hour wasn't enough. And I think even if those 2 sessions weren't enough, but you must have a look at it. The problem there is that the entry level, they say that it has to be lawyers. That's one end. Then they go through a process of lawyers having to give an exam to be a mediator. And she was saying there is no bar exam. Can you imagine? There's no bar exam for mediators. I don't know what this whole thing is, that you have to give an exam, and then you have these various trainings on an ongoing basis. How are they looking at mediation and mediators? I think that somewhere has to be understood what that thought process is, because it has so much. Getting into so much on their end and not looking at it from the general legal practice. I think that's one thing. Then on the other end, that came out from the symposium was that arbitration and arbitrators are not regulated. But for some reason, this whole thing of qualification, certification of mediators, here an arbitrator is going to give an award which is binding on you. Of course, for some reasons, you can, of course, challenge it. That's a different thing. But it's supposed to be binding on you. Here is a person who's assisting you. It's not, there is nothing binding on the whole process, or on the settlement is your settlement. Why is this over legislation on this end? I have to really understand this. Where is it coming from? Is there some threat to the lawyers? That is why it's being put across, and lawyers have a say in things in the country. Is it that? But this is something that really comes. So when I keep saying, I've been saying throughout this symposium, that legislators don't have any qualification or certification required. Point being that if you trust someone, why should that person not be your representative? Why doesn't that mindset and thought process come into mediators and mediation? It's their trust. It's the trust of the people. Who are you to come in between that trust? So that's like the kind of thought that is coming out from the symposium. And now your thought on that is important.
Yeah, I don't know how it's working in India, but in New Zealand, you don't have to have any specific qualification or certification to hold yourself out as a mediator. And except if someone said to you, could you please help me resolve this dispute? There'll be nothing stopping you from doing that. I think there is a drive. People do training. People do get certified. They do go on to panels. I can't tell you why. That's something that I've done. Has it helped me in my practice? Not that I can tell you. Not that there's nothing obvious that I can say that this has helped me as a mediator, either improving my standards, my practice itself. Has it got me more work? I'd say the answer to those are no. I think going and speaking to my colleagues and doing reflective practice with them is probably the best training that I get. Where and we've got a really great, as I'm sure is across the globe, I've got a really good network of mediators here that I speak to regularly, where we talk about our practice and what's going on, bounce ideas off of them, and for me that's the best way for me to improve as a mediator. But yeah, look, I think Vikram, that mediation is continuing to move into certification. I was talking to a friend of mine in London last week, and he's director of the barristers' chambers, and he was saying to me that they can't put anyone on their mediator panel now unless they are. And you've got to be a member of, I think it's called the Civil Justice Council in England.
CMC, Civil Mediation Council.
Yeah. So this certification's not going away. So it's people in England are now a member of the Chartered Institute. They're now a member of CMC. I don't know that this gets them any more work. It's definitely a way for organisations to make money from people. That's for sure.
And you have to understand, those vested interests will, of course, they're making money. And look, to a certain extent, I've been saying that corruption also will seep in, because definitely in a legislation, if you say that certain people are the ones that you have to go to, and it's huge for those institutions, so that can they will try and influence legislation for sure when things are developing. But in general, you'll create this whole thing. Okay, this is what is actually something which is you have to go for, and because of it, obviously those guys will keep doing their work, which is not going to be good for mediation, because there'll be so many disillusioned people coming out. And of course, Rosanna's here. Rosanna, is that name going to be stayed? Is it going to stay in Russian, or is it going to be changed to English? What is the plan?
Oh, sorry. I'll change it.
No, it's good to have the Russian name. Yeah. So I think we're just wrapping up Darren's session on that. But I think, Darren, I think what's coming up in terms of you said about numbers in the UK, about that there was a CEDAR audit. I mean, there are no numbers. I mean, if you look at it from that, even if the whole you say certifications and everything happening, but there are 18,000 certified accredited mediators in UK, and total in commercial. Okay, we have that figure 17,000. Is what CEDAR has put out there. The others I also won't know, but there are no numbers there. So what are you really wanting? It's not going in the right direction. Why keep doing it? So now it's about people experiencing it, and that's what we are going to do, Darren. World Mediation Circle, let people experience it, and let legislation not come in the way. And why are you saying that in terms of Singapore Convention, the thing is that if it's signed by New Zealand, and a domestic legislation comes up, you should be part of that to put in these thoughts that do not complicate it for the user, and keep it something which is their process.
Quite. I know there's been a few changes to a few acts where myself and a number of other mediators have given submissions to the government with our thoughts on it. I think they were all ignored.
That's good. Like I said, there has to be maybe a lobby which has to be. You have to create a lobby, it seems. Okay, that's what. Right. Let's see how it happens. I mean, we'll try our little circle becoming a lobby, which is what I was saying. But you mentioned reflective practice groups. I am going to be setting those up, which is part of the World Mediation Circle. That's one part, that reflective practice groups from people from around the world to be part of. So that's going to come up. But the thing is that when am I going to do it? Now this ends, then we have a World Mediators Conference coming up from 18th May. When is the World Mediation Circle going to get focus? I don't know, but hopefully.
We need to get you a cloning machine, Vikram, so we can have two of you.
You people are supposed to be that. You people are supposed to take it forward. Now, Rosanna is a busy woman. I've been wanting her to get involved, and she's like changing the whole mediation scenario in Kazakhstan. But what about us, Rosanna? You have to be doing things for us. So okay. So Darren, any concluding remarks? Then we'll get into Rosanna's session. Anything?
I've read I think there is a really good opportunity in New Zealand to have an act that's quite basic and just gives mediators the real flexibility to help people in designing their process, and that's not prescriptive, that doesn't tell you how much you should get paid or how much terms you should get employed on, and to keep all of these different divergent terminology, processes, procedures, protocols, throw them out the window, and let the mediators get on with what they can do best, right? That's my view on legislation, is have a basic act and let us work around it.
Only thing is that right at the end, you've touched on the remuneration part of it. I think in terms of remuneration, that in the legislation and how the judiciary self-interest is creating that issue about the free part of it. That's another discussion, maybe because Rosanna will take it up. So Darren, thank you very much. Always a pleasure. And let's do things in New Zealand in terms of the World Mediation Circle, right?
We will. I'll be in contact soon. Thank you very much, Vikram. And Rosanna, I'm sure you have a great session.
She will. I'm doing amazing.